All right, don't be shy. And also, I hope I do not butcher the next introduction. Uh, all right, folks. So now, if you do not mind, as you all make your way over, please join me in welcoming to the stage Jen Mellett, Office Managing Partner at Freshfields, to kick off our next conversation on the impact of antitrust and M&A, as well as introduce our next panelists.
Hi, everyone. So I think we are the panel here to react to everything you've just heard from Henry and before that from Olivier to see how we really feel about all of this playing out in practice. But before we get into it, let me introduce the panelists who've joined to talk us through it. So first we have David Altschuler with us, who is the Vice President and Assistant General Counsel for Competition at Salesforce. We have Kevin Yingling, who is Director of the Competition Legal Team at Google. And then we have Colin Raftery, who is a partner at Freshfields in London, but until very recently was the Senior Director of Mergers at the CMA.
Good afternoon.
Great to have you all. So I think let's kick it off by reacting to some of the points that we just heard from Henry about the FTC's enforcement agenda. Maybe taking the merger guidelines first, and David, I'll pick on you. You know, the way that Henry framed this was that the merger guidelines we've seen from the FTC are not really a sea change, and it's just business as usual over there. These are the same theories we've seen before. You know, you sitting as a competition advisor within Salesforce, is that how you think about it, or do you perceive there's been a change in how these conversations happen?
So I'd say a yes and no answer. I mean, look, on the one hand, what the DOJ and the FTC do with merger investigations isn't changing. The exercise of collecting documents, interviewing market participants, looking at economic evidence, and following the facts, and seeing where those go. That fundamental discipline remains, and I think on the lion's share of cases, outcomes remain similar to how they are in the past because the discipline hasn't really changed. I mean, I was at the Antitrust Division for over 10 years and worked on a lot of investigations, and the number of times where we sat in a conference room and discussed all the things I just described was all the time, and the number of times that we sat in the room and discussed the merger guidelines, I could probably count on one hand, which is not to say that they're not significant, because they are, and that'll get to the second point. But I do think that the kind of fundamental exercise of investigating mergers remains the same. And I also think that the number of deals, while not insignificant, the number of deals where some of the changes in the guidelines come into play relative to the total number of deals is relatively small. So in those ways, I don't think it's a sea change, and I agree with a lot of the things that Henry said. That being said, and Kevin and I are going to kind of play off of each other, but there are certainly areas that are significant departures, at least in how they're written with respect to the past. I'm not going to catalog all of those, but two of the areas that I've been watching are, number one, vertical mergers, for those keeping score at home, guideline number 5. If you read guideline number 5, at least, and when I read it, I see a much more skeptical eye towards vertical mergers than in the past. Vertical mergers, I know we're not all antitrust lawyers here, but when you're in a vertical merger investigation that's premised, for example, on foreclosure, a merging party is often in the position of having to prove the negative, and that's already a difficult task. And when I read the guidelines with respect to vertical mergers, it has kind of an element the heads I win, tails you lose in favor of the government. And I think it will be interesting to see how it plays out in actual investigations and whether there's really the change in emphasis in the guidelines changes outcomes. And then the other area that I'm watching, and you heard Henry talk about this, was potential competition and potential entry. The guidelines look at the question of whether an acquisition eliminates a potential entrant in a concentrated market. We hear a lot about killer acquisitions, and I think that makes a lot of sense, and that has always been a part of merger analysis. But the ways, without getting into all of the details, the way the guideline talks about how you look at potential entry and the fact that it can be an objective assessment of market facts and incentives that emerging party may not really know because it doesn't turn on a subjective intent of what you're actually going to do, but at how the government looks at surrounding circumstances and incentive and ability and makes some kind of calculation. I think that's a very challenging thing for emerging parties. And then there's a clear preference, which is written in there, on organic innovation over acquisition. And I know tech companies in particular, but all companies make build versus buy determinations all the time. And I think reading the guidelines, there's a lot of uncertainty about how, when is that determination going to become actionable in a way that lands you in a significant investigation. So that's just a couple of things that I've seen. Kevin,
Yeah, no, I mean,
your thoughts.
that sounds exactly right to me. Certainly a lot of the rhetoric, I think, coming out of the agencies is fairly aggressive, right? Neo-Brandeisians, Lena Khan and Cantor, right? They're talking and they're suggesting that antitrust policy over the last 40 years, focusing on consumer welfare effects, was really just wrong-headed, right? And taking on a new approach. But I would say the guidelines are probably a little bit more modest in the approach. And definitely agree with David in terms of areas of emphasis, right? Sort of elevating the vertical guidelines into just sort of overall merger guidelines, the focus on nascent competition, potential competition theories, also concerns around entrenchment of dominant positions and platforms as also being areas of focus for the regulators. And for folks like us on the antitrust world, we've seen the antitrust leadership focusing on those areas. So it's not surprising that the guidelines are picking up on those themes. And then I would say, in practice, what you're seeing, again, I think is somewhat more modest in terms of what the agencies are actually doing, right? So recently they sued to block Kroger Albertsons. It contained a claim about unionized labor, which is a little bit unusual. But then it also has paired with it just a traditional arguments around consumer harm in terms of price effects and quality effects. So it's sort of that pushing the envelope while at the same time focusing on more traditional theories.
And looking at the transactions that we work on today, I think it is more often than not these days the rarity that the U.S. is the only jurisdiction that you're contending with. Kroger Albertsons is really one of the exceptions there. And so the EC, the CMA, SAMR are often at the forefront of folks' minds. And Colin, I'm interested to hear from you, hearing Henry say, traditional theories of harm, largely business as usual. Olivier said the same. He said most cases are still horizontal. But we do hear more about dynamic competition, about ecosystem theories of harm. And you've just come out of the CMA, which is often at the front of a lot of these conversations. So how did you think about this when you were at the CMA?
Yeah, so the CMA has been through a similar process to the US agencies, and it adopted its own new guidelines in 2021, and they were the first refresh of the guidance for about the same period. The previous substantive guidelines were adopted back in 2010. And when you look at the UK guidance and you look at the US guidelines, I think you see huge similarities in practice between the two sets of documents. So when I look at the core guidelines in the US and you look at the 6 core guidelines which describe the main theories of harm, each of those sets of circumstances also forms a core part of the UK guidelines. So you see there's a lot of substantive overlap. I think you see quite a similar process as well, where the agencies are asking themselves, what do the underlying laws actually say and how should they be applied in practice? So there's a bit of a kind of back to basics approach where they're actually looking at the statutes and they're actually looking at the case law and they're perhaps gliding over more administrative practice, which it perhaps is no longer completely consistent with what those underlying laws and principles say. And actually, vertical merger enforcement is a really good example. So in the UK's 2021 guidelines, one of the most controversial aspects was the removal of a statement that said, well, look, it is a well-accepted principle that vertical mergers are generally benign and do not give rise to competition concerns. So that was taken out on the basis that, well, that's not really a statement that seems to be consistent with what we're seeing in the case law or what we're seeing in practice. But in the 3 years since those guidelines were introduced, so we've got a little bit more time to see what their impact has been in practice, the CMA has found competition concerns in a number of cases, but only in one single vertical transaction. So the idea that change in the guidelines has opened up the sort of floodgates to a whole new sort of flood of vertical cases is probably not consistent with what we've seen in practice in a sense. So I think there is still this same balance between principle and practice, which in the US is now going to be played out.
So I want to also pick up on the points that Henry made about the new HSR form, which is one of these things that's very technical and process-oriented. I think it's easy to say, well, this doesn't go to whether we can close, but really can have a significant impact on timelines and on burden and on cost of companies to get through these processes. And Henry explained that the new HSR form that we're going to expect soon is significantly scaled down from what was a very scary proposal that we saw several months ago. But Kevin, I'm interested to hear from you. Is this change to the HSR form necessary? Does it give the DOJ and FTC a lot of information they didn't have access to before?
Yeah, look, it's going to be really interesting to see what ultimate rule or how the form is going to look, right? So the proposal from last year was just incredibly burdensome. It had additional document requirements. Folks may be familiar with the Item 4C or Item 4D documents. These are the transaction-related documents that go up to officers and directors. The FTC was advocating expanding that to a supervisory deal team lead, and that would be somebody who has day-to-day management over the deal, and that's going to create just a lot more documents that you would have to produce. Also demanding drafts of documents, which again, I think everyone's familiar with how many drafts can be created around these kind of deal decks and those kinds of things. So the volume of production would just be much more significant. Also demanding narrative responses. What's the strategic rationale for the deal in terms of horizontal competition? Are there product overlaps? Are there potential competition issues? Describing labor overlaps. Also providing a lot more details in terms of officers and directors and board observers. So their positions within the corporate entity, but then also their positions outside the corporation and other entities. So we're doing a fishing expedition for Section 8 interlock information. So a really broad, expansive proposal, and not surprisingly, the antitrust bar and others didn't react that well, and I think they got over 700 comments. So certainly hopeful to hear that is going to be scaled back. But Lena Khan and the FTC and DOJ leadership, when they talked about it as enhancing efficiency and effectiveness in identifying potentially problematic deals. But I think I'm sort of skeptical, right? So certainly it's not a more efficient process. I think currently now to put together an HSR form, you're looking at a week, 2 weeks, something like that. Talking with practitioners. Under the proposed form, we're probably looking at 2 months or more before you can gather all that information and actually get the clock started. So certainly not a more efficient process. And I don't think it's more efficient for the agencies, right? So they've suspended early termination of the HSR process, because they're sort of understaffed. I think Henry mentioned, that they have capacity constraints. They'll issue these warning letters because they're not done with their investigation. And the idea that adding all of these documents, adding all these narrative responses that conscientious FTC staffers, DOJ staffers are going to be reviewing, there's just no way they're going to be able to get it done in 30 days. So question whether it's really more efficient. So then you say, well, okay, maybe it's more effective in identifying these sort of problematic transactions. But if that were true, you would sort of see a systematic systematic under enforcement in challenging transactions that are consummated, right? So if you file an HSR and then you have no second request, then there's a chance, or it's more likely that deal is challenged or could be challenged at a future time, and you don't really see that. So I don't think it's likely that there is a problem with the form not being effective. So ultimately, I think we'll have to see what the agencies do. But it'll be an area of ripe discussion for sure.
Yeah, and to your point on, you would see a lot of effectively missed transactions if we'd had a different form. Yeah. Colin, I might pick on you here, but in the UK, you have this long form, and it's normal to issue what are called Section 109 notices in merger processes where you get thousands of documents. And, did you feel that put you in a superior position to the DOJ and FTC with their tools to pick up things that they were missing?
Yeah, I mean, I think what you have to remember is the UK system, you're looking at a much, much narrower scope of case. So the CMA will only open about 55 to 65 formal investigations each year. So, I mean, we'll talk about it a little bit later on, but there's an alternative light touch regime which the vast majority of M&A activity goes through. So if you have a formal investigation in the CMA, it tends to be that you're one of a narrower set of deals that are probably a bit more problematic to start out with. So I think you see this dividing line in the UK where once you have an investigation, it's quite a serious thing, but you have all these other deals that can go through in quite a light touch way. And I think certainly in that circumstance, for that kind of deal, having the fuller merger notice and having the documents, the sort of internal documents, are a really, really important part of the process. But there's also, some risk for competition authorities. When I was at the CMA, we worried quite a lot about the length of pre-notification, because when you have a big industry-defining transaction, it's not just the merging parties involved, but it's also third parties and customers and suppliers whose thinking is affected by the fact of the transaction. And inevitably, there's some chilling of investment plans during that period. So I think certainly when I was at the regulator, we were always conscious that there was an important benefit in kind of getting on with things a bit sooner rather than later. And look, from my personal perspective, I think it's really important for competition to work well, that isn't lost in the debate.
Just to pick up on one thing that Colin highlighted that I think is important, zooming back to the United States. I mean, I think a lot of the consternation about the forum, and I agree with Kevin's point, has been that it applies to all transactions. And that's what really distinguishes it from the UK regime or the EC regime, where it's a much more narrow subset. And you'll hear the agencies say this all the time. The vast majority of transactions that they see when they see X hundred or thousand HSR filings a year pose no competitive issue, and they get closed and cleared within 30 days now that we don't have early termination. And I think when you looked at the initial HSR proposal, the impact of that will be the most felt on that those smaller and mid-sized transactions and those transactions that pose no risk of competitive harm. And I hope, I've heard Henry now say twice in 2 weeks that we'll be pleasantly surprised by what we see. I think we will still see a significant and consequential expansion, and I think the effect of it will be disproportionately felt on transactions that otherwise wouldn't pose an issue. And I think there are very legitimate questions as to whether that's an appropriate balance.
Yeah. Just to quickly pick up on that, but there are also just better tools that already exist, right, for the staff at the agencies. So they can already look outside of the actual HSR form and do their own research online. There's way more information available to them than there was when the form was created back in the mid-'70s. They can also ask for voluntary access letters and get information that way, sort of insist on meetings, CIDs, pull and refiles, even targeted second requests, right, if they really wanted to focus on a specific area before trying to litigate. So there are lots of tools available to the staff.
Yeah, and David, I want to pick up on this point you made about burden, because there might be people sitting in this room who've not really thought yet about the fact that what used to be a 10-page technical form that you could fill out in 20 minutes if pressed to a 60-page written narrative response that will take weeks, if not months, to prepare. How are you at Salesforce thinking about how you're going to grapple with that added burden on a transaction?
I mean, I think it will obviously be a challenge at any company that does a lot of acquisitions. I really think right now, in the way that we've looked at it over the last couple months as we await the final rule, is it's really an exercise in expectations management. So we talk to whether it's our corporate development team or all of the legal teams that support M&A, and we basically have done a roadshow explaining what this is, at least as proposed, and what the ramifications are. I think it's hard until we see the final rule to do all kinds of changes to processes, internal processes that I think the ultimate final rule will require. But one thing you can be doing now is collecting the categories of information that you're going to need on every deal. I mean, Kevin spoke some about the expansion. There's kind of two categories of expansion. There's expansion of information that you have to provide about your company, and then there's a significant expansion in the amount of information and documents you have to provide around the deal. Around a deal, there's really not that much you can do now other than starting to make people aware of what you're going to have to do and the changes in cost and timing. But with respect to the company information, for example, that's information you can start to pull together. But even doing that, I think on the other side of the final rule, there are going to be a lot of challenges, and people have to understand, to the points that were already made in the US, that the timing and cost ramifications of that are going to be significant. And the last thing I'll just say is you also have to think of it in both parties of the transaction. So you could be an acquirer, and you could be the best prepared in the world in terms of pulling together this information and being on top of all of these things you're going to have to draft. But it takes two to tango with HSR, and that's going to be another thing to watch. Like, merging parties are going to have to both be up to the task of really aggressively taking on these new requirements to mitigate the impact on timing.
So, Colin, I want to pick on you a little bit about the time at the CMA. When you talk to clients out here in Silicon Valley, all over the US, I think for the past few years, it would probably be fair to say that a lot of times you hear the CMA referred to with, shall we say, language that I would not repeat in front of my mother. And I wonder, if you can talk a bit about the experience of the agency and this feeling that people have about the CMA, that they are trying to be the next big kid on the block and be really aggressive and establish themselves as a core regulator here. How did that feel kind of on the inside?
Yeah, so look, I mean, I think it's worth taking a step back and thinking about what's the CMA doing and why is it doing it. And certainly from 2018 onwards, I think with some echoes to what Henry was saying earlier, the CMA was really worried about under-enforcement. And that was in part driven by data about increased profit margins and increased concentration. But it was also driven by what it was seeing as a competition and consumer agency in markets where consumers and businesses were bringing problems to the agencies about really poor outcomes in markets. And a number of those markets happened to be markets where there had been merger activity in the past, and those deals had either been cleared unconditionally or cleared with remedies that turned out not to work that well. So the CMA sought to revamp its approach to merger control. It started to use its quite expansive jurisdictional powers to the full extent. It adopted a more robust approach to competition assessment, both by having a kind of zero tolerance approach to further concentration in already consolidated mature industries, but also by pursuing these broader theories of harm that we've been talking about today in new and developing industries. It also adopted a more robust approach to the assessment of remedies, I think, with a particular skepticism around behavioral remedies and carve-out remedies. And of course, when all of this was happening, it was at the same time as the UK's departure from the EU. So as of 2021 onwards, while large global M&A deals had previously fallen to the European Commission to review exclusively on behalf of all member states, including the UK, the CMA was now looking at these deals in parallel. So what we saw was this more muscular approach to merger control being brought to bear on larger, higher profile global M&A deals. So what's the CMA trying to achieve ultimately? Look, while the CMA takes this role really seriously, my experience was not that it's trying to position itself, as some have suggested, as a kind of global policeman for merger control. So it's not doing the bidding of other agencies. But equally, where it sees that a deal has a meaningful impact in the UK, it is not, I think as its track record shows, going to take a step back where the business is involved or non-UK entities, or where other authorities have come out in a different place, either on the substance of the case or on whether remedies can be offered that fix those concerns. And when you look at deals like, say, Microsoft Activision most recently, but even before that, something like Cargotec, Konecranes, which got a lot of attention in antitrust circles at the time, you can see that the CMA is willing to be the kind of last man standing, to be the sort of determining, to have a determining outcome on global M&A deals.
And so you just mentioned the Cargotec Konecranes deal, which is traditional heavy industry. I think Olivier made the point that a lot of the enforcement actions we've seen in the last few years are still in very traditional markets. But there is this feeling that tech is really in the crosshairs, both in active enforcement, but also in new regimes like the DMA and the DMU. Do you think that there's a real focus and emphasis on tech in particular here, or how should the companies out here in Silicon Valley think about that?
Yeah, look, I mean, for what it's worth, I think Olivier is completely right. When you look at the numbers on where problems are being found, you have new merger guidelines that have more of an emphasis on innovation competition, potential competition, non-horizontal theories of harm. And there have certainly been high-profile examples of intervention in that kind of case. Microsoft Activision being a really well-known example in the UK. The prohibition of Meta's acquisition of Giphy being another. But when you look at the cases that generate by far the vast majority of interventions, you're looking at horizontal overlaps between existing competitors. And in fact, when you sort of look underneath the surface and you see what are the key characteristics of these deals, you see really common red flag issues. So you see high market shares, concentrated markets, a lot of head-to-head competition between competitors. So I think that still does account for the vast majority of merger control enforcement in the EU and the UK today. You do see a new approach, as set out in the merger guidelines, to these cases. Many years ago, if you had a company that had 0% market share, it would probably have waved through really, really quickly. But what you will now find is, stripping back what's on the surface and saying, well, what's the rationale behind the deal? Why is the incumbent buying this business? Has the incumbent been reacting to innovations that have been made by this business over time? So I think there is a definite focus on tech, but equally, I think there's a really strong focus on industries that have a lot of the same characteristics. So life sciences is another good example as well, and green technologies in the UK. I think they are two sectors with similar characteristics where you see a really strong focus as well.
So taking a step back from the CMA and looking more globally, Kevin, one of the trends that we really have seen in the past few years is what I would call jurisdictional uncertainty. So you have the CMA who's come onto the radar with the share of supply test. You have the EC being much broader with what we call Article 22 referrals, all going to this point that they want to be able to call in deals that they think are problematic, whether they're reportable or not. And that creates a lot of uncertainty for a company about to sign a transaction, because it's no longer easy to say, here's our list of filings, and here's our timelines, and here's how this is all going to go. So what are you doing to cater for that?
Yeah, no, it is. It certainly creates a lot more uncertainty for us when we're looking at deals, right? So you can't just get the global revenue or global turnovers and go and analyze it country by country as you used to do, right? So the CMA, as you said, with the share of supply test, and I'm sure Colin could talk at length about this, but it's just a really flexible, elastic standard that allows the UK authority to pull in almost any transaction, even if there really is no revenue, no turnover in the UK. And Colin mentioned the Meta Giphy deal, which was an example of this. Again, the CMA potentially flexing their muscle post-Brexit in 2020. Meta consummated the Giphy deal, and the CMA came in, investigated, and found they had jurisdiction, and ultimately forced the parties to unwind it with Meta sort of selling it off at a fraction of the price. And then the EC, as you said, has Article 22, which they've reinterpreted to where a member state that doesn't have jurisdiction can somehow refer it back to the EC, which also doesn't have jurisdiction, but yet that conjures up jurisdiction for the Commission. And that was implemented in Illumina Grail, which they're contesting right now. General Court found against them. The Advocate General has actually found for Illumina. We'll see what the European Court of Justice ultimately does. But the EC's made it clear, even if they lose that authority, they would still potentially bring cases under 102 as an abuse of dominance, which they're doing in TowerCast. So there's still sort of that uncertainty overlaying our deals. So look, I think you have to really look, is this the kind of politicized deal? Is this in a hot sector? Is this AI? Is it healthcare? Is it tech that regulators are likely to be interested in? And you sort of throw the revenues aside and just put on your regulatory hat. Is this front page news? Is this something that would be interesting? You may also look at revenues and then deal value, right? And if the deal value is a large multiple to what the revenues are, maybe that suggests to regulators that there's going to be a large market impact despite what the turnover is in specific jurisdictions. So we're putting on that hat and doing that analysis. If we do think the CMA might be interested or the EC might be interested, there are opportunities to do briefing letters. So you can send a briefing letter to the CMA and get a read on whether they're going to call it in. The EC, you may be able to do an informal consultation to get a sense for whether an Article 22 could be of interest. So there are steps, and then obviously you have to paper that over in your merger agreement to make sure you're covered.
So I think there's actually a really interesting new front on this. There's been a lot of discussion in the last few years about the share of supply test, but one of the aspects of the UK regime that's probably had less attention is the CMA's ability to assert jurisdiction over transactions that fall short of full control of a full business. So the CMA can look at minority acquisitions, but it can also look in some circumstances at acquisitions of only certain activities of a business. So when you are thinking about a sector that Kevin mentioned, AI, and you're thinking about, for example, Microsoft's recent spate of activities involving OpenAI, Inflection AI, and Mistral, they're all arrangements which involve the acquisition of minority shareholdings or some other form of arrangements. And when you're looking at the universe of merger control arrangements that they could trigger, it looks like they are far more likely to trigger UK merger control jurisdiction than jurisdiction in any other country. At the ABA conference that Henry mentioned last week, the CEO of the CMA said that the sector was an area of concern, and it was an area where they were planning to step up their merger control enforcement. And it might be the case that other authorities have other tools to think about the competitive implications of these transactions. But given that merger control tends to run a bit quicker than most other antitrust proceedings, then the first potential antitrust point of friction for a lot of these arrangements that are being entered into now might well be in a UK merger control investigation.
And that's interesting, Colin, because you're looking at somewhere where the CMA is pushing the bounds, trying to be more expansionist to make sure it's looking at a certain type of transaction that maybe previously would have been less in the crosshairs. You heard Henry echoing Commissioner Vestager earlier saying, if I knew before what I knew now, I would have been bolder. And I'm curious, to what extent, on the opposite side of that balance, do regulators like the CMA think about the burden that this places on companies and the cost and the time that is associated with these ever expansionist processes?
Yeah, I mean, if it is some consolation, I think the answer is a huge amount. Certainly, agencies themselves tend to have limited resources. So, certainly from the UK's perspective, we couldn't overburden a deal with too many questions and too much information, because we would have other deals in the pipeline that would be coming in. So, the deal had to come in, be investigated, and moved on. And I think certainly there is a broader awareness of the burden that these investigations impose on businesses, because having worked on both sides of the table, they're incredibly burdensome in terms of the information required, but also they just stop strategic thinking within the business to a large extent, which is a really big risk when you're talking about an investigation that is 12 to 18 months long. And I think in the interest of wanting competition to work well, you generally want it to be a start, middle, and an end to the process so everyone can move on.
So we only have a little bit of time left, but I do want to talk a bit about what you all do in a deal where there are significant problems and where there is something that has to be fixed. And this is somewhere that we really have seen a divergence in the last few years between the US and other regulators, where the EC, the CMA, they may be very careful about the remedies they accept, but they are open for remedies, whereas we have been hearing in the US that remedies are just not something the agencies are interested in anymore. And David, maybe I'll go to you on this, but when you have a deal that has to be fixed, how do you navigate that US process these days, and how do you make sure that if you sign a deal, there's a likelihood that you're going to be able to close it?
Well, I will not speak from personal experience here because we have not had a deal that has to be fixed, but just observing, I think it's a really great question, and I think the first place you have to start right now is be looking at the different jurisdictions, because to the point that you just made, there's a divergence on the approach to remedies across jurisdictions now. There's a divergence in terms of which jurisdictions will take remedies at all. There's a divergence as to what types of remedies that an agency will take. So is it a jurisdiction where it will only look at a structural remedy, which has long been the preferred remedy, or will it look at a behavioral remedy, which in some jurisdictions, including the European Commission on appropriate facts, they will consider. And so I think one piece of that, a big piece of it, is you have to look at where are you going to be filing and where might you run into problems, and then what is that jurisdiction's approach to remedies. And one interesting thing in the United States, and I'm just parroting what I heard at the ABA spring meeting last week, is you see a big divergence between DOJ and FTC right now on this. Historically, because we're not all antitrust nerds in this room, the common way that you resolved a merger investigation that was fixable, so if you had issues in a particular product or geographic market, but the rest of the merger was pro-competitive, is you'd negotiate with the Department of Justice or the FTC, and you'd ultimately enter into a consent decree that was then entered by a court that would basically affect the divestiture of the remedy and ensure that there was ongoing court supervision of that remedy. And there were probably, if you look at the records, at least a dozen of those at DOJ every year, and similarly at the FTC. And since the division has been very transparent about this, since Assistant Attorney General Cantor took over, they've had 0 pre-complaint settlements, and they've had 1 consent decree, which was in the middle of a trial. And that's a real significant change. And the message that I heard last week from division officials was, if you have a problem with your deal, it's not our position to fix it, it's yours. And we've historically called that fix-it-first remedies, and historically, again, the DOJ and the FTC have looked very skeptically on fix-it-first remedies. They always wanted them to be resolved via consent decree. And flashing forward, I think what you see right now is the DOJ has been very clear that it's not going to accept consent decrees. The FTC has made very strong statements about the importance of effective remedies, but the record shows that it's still embracing consent decrees. So another complication is if you're in the United States and you're thinking about this issue, it could matter whether your deal is reviewed by the DOJ or the FTC in terms of how you think about it. Kevin, I'm curious about your thoughts on this too.
At the spring meeting, I think it came through loud and clear from both agencies that they view their role as law enforcement, really. It sounds like some of the data shakes out that certainly the DOJ is more skeptical, but I think FTC officials would echo the sentiment that they don't want to play investment banker or deal lawyers, right? That they're there to do law enforcement and judge whether a transaction is pro-competitive or anti-competitive. And if they view it anti-competitive, they're going to start getting ready to go to court. I think another interesting point on the fix-it-first is when you're thinking about it, so certainly one audience is the agencies, but then a second audience is ultimately a judge, right? So if you give yourself enough time in their merger agreement to actually litigate, You can take the remedy and put it in front of a judge, even if DOJ or the FTC has rejected it. And some parties have had success with that. So yeah, Assa Abloy, United Health Change, where the judges credited what the parties put on the table in terms of a settlement. Now it needs to be credible, right? So DOJ was successful in the JetBlue Spirit deal, where they convinced the judge that the assets that were going to be divested weren't going to necessarily stay in the market, and the judge ended up blocking the deal. But there is a second bite at the apple, even if the agencies don't buy your fix.
That core point is very important because I think the ways that parties are thinking about litigating has changed, at least the United States, significantly in the last 2 to 3 years watching this, because that can be the only option if you can't come to terms with the agency.
Yeah, and I would add a third audience into your bucket of audiences, Kevin, which would be the taker of the assets. So if you've got, I think the agencies are really alive to this idea that it's always possible to sell something to someone at some price. But if you're in a world where you've got a really attractive set of assets that are being sold to a really good purchaser who wants to invest in those assets and grow them, and it's something that the merged business almost feels a degree of commercial discomfort about because they're worried about how good a competitor this divested business is going to be, that's the kind of remedy that I think has the characteristics that would make it over the line, even with this new kind of higher bar for remedies that we're seeing at the moment.
Yeah, and it's interesting that there can be a divergence there, right? So thinking back to the United Health Change deal, where the divestiture, I think, was to a private equity firm, which the agencies are generally very skeptical of. But again, the judge found, I think it was TPG, like a credible buyer that they could run the business.
Yeah. And with that, I think we are at the end of our time. But I think it is clear from the agenda for today that antitrust is something that is really at the forefront of everybody's minds. So I want to thank the three of you for joining to tell us about the specific topics that are at the forefront of yours.
Thanks, Jen.
Thank you. Thank you.
Thank you.